Matter of Save America's Clocks versus the City of New York, number 17.
May it please the Court, James Rohonda for appellants. I'd like to save 1 minute for rebuttal.
Yes, sir.
Respondent's argument with respect to public access and mechanical operation cannot be squared with the plain language of the statute, the purpose of the statute, or this Court's decision in Teachers. It would have been quite easy and extraordinarily easy for the legislature to say, or to write the statute to require public access, or to require continuous operation. They did not do that. A lot is being placed on this word use, use of an interior landmark or use of an interior landmark feature. But use doesn't mean public access. Obviously, if use meant public access, then every time a door, a window, a gas lamp, a clock, these are architectural features, every time they were designated, then public access would be required to every one of them. Every gas lamp, every fireplace, every door, every window.
But isn't the original historic designation, that landmark designation, based on it being this interior item, the mechanics of it, and you can't designate that without public access, right?
No, there has to have been, this goes to their definition of an interior landmark. Mm-hmm. At the time, there are four things that, as they break it down, that have to that meet the definition of an interior landmark. It's got to be 30 years old or older, customarily open or accessible to the public, and a special historical or aesthetic value. And what they say is those are all in the present tense, and that's okay for designation. But then they say there's a fourth requirement, and this fourth requirement is very important, and there's a very plain language understanding of that. If we just stop with those three, then the lobby of the pre-war co-op building in Manhattan, every one of them that had any aesthetic value would be an interior landmark.
But are they designated as such?
No, that's why it says they
That's
have
the
to
point.
have been designated.
The point is the designation. And the designation is based, as you've correctly pointed out, in part on the public access. So once you no longer have public access, how is it a landmark?
It's a landmark because it's been designated a landmark and it's been preserved.
Then would you not have to rescind the designation to no longer have it satisfy these three factors? I mean,
No.
That's a definition.
No, and in fact, that would be inconsistent with Teachers, because in the Teachers case, the court looked at that argument. That was the case that involved the restaurant, the Four Seasons restaurant. And, you know, one of the...
I understood the court to be saying the fact that it could be closed off to the public doesn't mean that you can't designate it as such when you have public access. Not that you are going to designate it as a landmark and then cut off the public access without going through the process by which you must go to decide it's no longer a landmark, right, to undesignate it as such.
I think the court, and I think there's a very simple way to read what the court said there, and basically I think that what the court did was reject the argument that you could landmark the space because it was different than a public building, and a private space might be a restaurant now, but might be converted into a private space later without presumably public access, and the court said that doesn't matter. Public buildings can be converted into private spaces as well.
Can I go back to your point about use for a moment? Because I'm not sure it meets the argument that's being made. As I understand the argument, it's not that an interior landmark must always be kept open to the public, but use means that the commission must at least consider the loss to the public of access in evaluating the application.
It has to consider the use. It doesn't have to consider the public access.
Well, but does use mean public access?
No, use does not mean public access, and that's where the teacher's case comes in. It, in fact, cites this relevant discussion about potentially cutting off and taking a restaurant and turning it into a private space. When the courts discussing that, it refers specifically to a law review article. And that law review article, it cites one section of the law review article. And the law review article says, it leads with a title.
Is the issue of taking?
No.
No?
The title of the section that it cites is called Rejection of the Public View Requirement. And it's a discussion that says it's still consistent with landmarking and the principles behind landmarking if you limit and indeed ban public access. That is still consistent with the purposes of the laws permitting interior landmarking. I think when you read that citation, you read what teacher cited to, I think Judge Kaye was clearly saying that we can landmark a space that's open to the public and it can be converted, the fact that it may be converted into a private space later does not prevent us from landmarking it now. Implicit in that is it doesn't have to remain a public space.
Can
be
you
privatized.
can you convert it to a private space that diminishes the historical aspects that justified the landmark designation?
Maybe not, maybe one of the purposes have to be met, and it will be, and this is a discussion that you don't have to meet every purpose. So for example, preservation, protection may actually be inconsistent with use. And there was a lot in the record about that. People traipsing around this space and the public being there may in fact harm the machinery and the clock. And so as long as you are meeting one purpose, and protection and preservation is the overarching purpose. But I think also if you look at those purposes, it's very interesting what it says about use. Use takes a back seat, in fact, to, this is in 301B. Section A of that says, the purpose of this, Section B says, the purpose of this chapter is to A, affect and accomplish the protection, enhancement, and perpetuation of such improvements. So affect and accomplish. When you get down to use, it says promote the use. That's in Section G, promote the use. It doesn't say affect and accomplish. It doesn't say ensure. It doesn't say require. And when it comes to statutory language, I think a court shouldn't nitpick that.
Except
that's an intentional.
Except that distinction is missing in 307E, which particularly refers to interior landmarks.
Yes, well, 307E and 307 in its entirety actually says this
Well, no,
should
but
be interpreted
307E
with the effectuation of the
307E
purposes.
is particularly about interior landmarks.
Yes, right, and it says,
We're dealing here with interior landmarks.
yes. And so use certainly doesn't mean, if it meant public access, it should have said public access. It doesn't say public access, and this court has interpreted public access.
What do we think use means? Use by what? Use by
Utilization.
whom? By whom?
That it is used, private or public, which is exactly what is the case is happening here. The clock will be used. The clock, in fact, there's a lot of alarm being raised by the other side, pardon the pun, about what's going to happen to this clock. It's very clear that in the COA, it requires the permanent operation of this clock. It will be used. The plain language definition of use is utilize, employ. The clock will be utilized.
But isn't
It
the
will be
original designation a particular type of mechanical use? And that's what's going to be missing. It's going to be unplugged, you've got whatever it is, the digitized lighting,
right, and to go
not running the clock by the hand mechanism, right?
Right, it'll be used in the common sense. It says or, electrical or mechanical, that's what it provides, and it allows the owner to use either. Just like a restaurant that has a gas lamp in
Can I
it,
just
the old
take a-
Gage and Tollner restaurant.
You don't have much time left, and I just wanted to, one area that I was curious about. How does the designation of and access to the clock area affect the value of that space, I guess the tower space, in terms of development?
It eliminates the value of it because
And
if
when you
it,
say it eliminates it, what are we talking about? What's the difference in value, say, between
Well,
what the property's worth now without that, or let's assume that there's not the designation on there now, and that in the future there would be. How would that affect the value of that space?
well, it couldn't be sold as a private apartment.
For what?
Tens of millions of dollars, likely.
see. And
it's
so
a
that
very
value is
significant-
eliminated then?
It would. And that is a critical.
Well, there's no
issue.
record on that.
No,
There's no real record on that.
No.
I had thought
Well,
excuse me, I had thought that there was a taking argument that had been made.
Well, there is a potential taking argument, because what's going to happen in cases like this is you're going to see potential people petitioning, saying, well, you've designated a theater on Broadway, the former Four Seasons restaurant. I want access to it. You know, those theaters on Broadway would be great for, town hall meetings and public meetings, because if there is a right to demand public access to everything that's been demanded or been designated as an interior landmark, then not only do you get to go there, you get to operate the windows, run the gas lamps, light the fireplace, if that's what it means. And it clearly is not consistent with the plain language of it.
Thank you, counsel. You have your rebuttal.
Thank you.
May it please the court, Diana Lawless on behalf of the municipal appellants. I'd like to reserve 2 minutes for rebuttal, Your Honors.
Yes.
Your Honors, I think it's important to go to what we were talking about. In the teacher's case was designation. At the time of designation, it turns on whether the interior or parts thereof is worthy of protection. We're here on a certificate of appropriateness. That's what happens when work is reviewed after there's
Counsel, on
designation.
that point, which I think is very important, I think the best argument there is, okay, you have this process. They can say yes, they can say no, right? This plan is submitted, they can say yes, they can issue this certificate, or they can refuse it, reject it. The best argument seems to me, it's irrational to accept a plan that, as a result of the plan, the landmark is no longer qualifies as a landmark, meaning the interior, the access to the interior. So what's the response to that? What is the authority, I guess, of the commission in terms of what the LPC, what can they do with respect to that interior landmark? Can they accept a plan that demolishes some of it? Can they, what is the authority? And how do you answer that argument that the best, that you cannot approve, because this is really approval or disapproval, you can't approve a plan that as a result of your approval, the item is no longer a landmark?
The certificate of appropriateness process itself, as set forth in 25307, envisions change and, in fact, radical change. A owner can come to the commission and say, we want to demolish this. The commission can determine, has to look at 2 things. One, is it consistent with the purposes of the landmark?
Can I ask you about that? Because I'm struggling a little bit with the language in 307. I don't see where it says you can, for example, demolish the landmark itself. It says, among other things, demolish an improvement on a landmark site or containing an interior landmark. But it seems to me that there's at least an argument that if what you're trying to do is demolish the landmark, that requires a rescission.
Well, Your Honor, I think that the demolishing would actually be, in fact, demolishing a building. An improvement is a piece of real estate containing an interior landmark. This interior landmark is 20,000 feet of interior space. What is designated is only certain parts of that, certain specific things. None of those things are public access. It is features in a room, so it looks at So the way I read the statute is if you were going to, say, demolish, you wanted to reconstruct a portion of the building, and it has an interior landmark in it, you could then go through this process. But if what you wanted to do is demolish the clock, which itself is an interior landmark, that's a rescission. That's a rescission of the designation of the clock as a landmark. Your Honor, I have to disagree. I have to say that the clock is a feature. It looks at the interior architectural features. The features are the things that are designated. The features are defined in L. We look at the style, design, general arrangement, and components of the interior. The commission does not look at in either public access at all, not how the building's being used, and we mean, by the way, use in the conventional sense of it's being utilized by the property owner. And it does not look at how the clock itself is going to operate. We can't, for example, tell you to keep your lights on. That's not what the commission...
But what if that's the reason it's designated as a landmark? Would that not make a difference?
No, Your Honor, and I will say you can be designated for a reason, but 25307 gives great discretion to the commission to decide what can be used, what can be done going forward. And that's because
What was the commission's authority to keep the banking hall open?
the banking hall was by an agreement. The public access to the banking hall was by the owner's agreement, which was memorialized in a restrictive declaration.
Presumably you asked for that.
No, we did not ask, but the record does not show that we asked
They
for it.
volunteered it?
Our position is we take the proposal as put forth. They volunteered it. We asked them to memorialize their voluntary agreement. These are real buildings, real things that are being used. We don't expect things to be look like they are in a museum.
Could you have required as part of your approval? Could you have required that they continue to allow public access to the banking hall?
No, because we only look at the work under 25307. That's the only thing that happens post-designation.
But you could then say, let's say they had put in a proposal that sealed off the banking hall from public access. You could just say no, right?
If the only thing was, we want to seal off the banking hall, if that was the only thing, this is a huge project. If the only thing was we want to close the door, we want to lock it, we have nothing to do. There's nothing for us to
No,
come
but
to.
my point being, if you felt that closing the banking hall was inconsistent with the purposes, which is, I understand, the standard for issuing the COA, you can reject a proposal.
We can reject a proposal if we don't believe that the work that's being done is consistent with the
But
landmark.
my
You
point,
look at the overall project.
Yes, absolutely.
and if you felt that that was the big enough part of it, the commission has, LPC can reject the proposal. They could come back and then open the banking hall and say, okay, now we're opening the banking hall, accept or reject. It seems to me it's a negotiation process that way. If you don't like it, you reject it, they come with something else.
I mean, I think that what really goes on is that the talk is all about the features and protecting the features. There's a great discussion, public hearings, public meetings. Everybody talked about the things that were happening, what the features were going to be used in this space. I don't think that the commission took an up or down vote on whether or not a door was going to be locked and who was going to go there. It's only as to what the effect would be on the features. And I would like to point out that the only mention in the statute about public access is in the definition section. There's-
Before you sit down, if it's okay, Judge, I just wanted to ask one area that really hadn't been talked about. It seemed that your opponents, that one of the primary arguments on the other side was that the decision by the board, by the Landmark Preservation Commission, was infected by an error of law. And you didn't address that at all.
Sure, it's not an error of law. First of all, the petitioners never showed that anything about the scope of the commission's authority was integral to the decision. The commission may have thought it was deeply problematic.
Well, the way I understood the argument is they were told they didn't have the authority to do something that they wanted to do. That's the way I understood the argument. And are you saying either that they were not told that, or that they were correctly told what authority they had?
There was nothing wrong with what the general counsel said. But to the first point, this is not a case where the commission had to specifically answer the one question, is there authority for public access? The commission was approving work. It doesn't matter. What the general counsel said was correct. The bottom line is that...
Well, see, that's a separate question. Whether or not it matters if what he said was correct is a little bit different from, say, a balancing approach. If they had the right information and they balanced the competing interests between everyone, then they were probably perfectly within their powers to make this decision. But if they made a decision under a clear error of law, then it may be a different situation. That's why I'm asking the question. So what advice did he give do you say was correct? What was correct, his advice?
The general counsel expressed the view that we laid out in our brief, which is that there's no public access mandate, and there is no mechanical operation mandate, which are the two things
How
that...
do we know whether they rendered their determination based on that advice, even if it was wrong?
We don't know, because views were presented on both sides of the issue during the public hearing, the public meeting.
And do we, as judges, have the right to go into the minds of these commissioners and make a determination as to what we think they based their decision on?
No, and that's something we brought up in our briefs that we thought was extreme error with the appellate division decision, where it kept going into that.
But why can we not presume that this entity, where members are asking questions, relies on legal advice, not just someone in the audience, not just a co-commissioner, but actual counsel's legal advice? Why can't we presume that they make their decision in reliance on that advice? I mean, what is the counsel there for?
The counsel is there to provide legal advice. We said the legal advice, there's no reason to believe that this project turned specifically on public access or turned specifically about the operation of the clock because of its size.
Even if several commissioners asked about it specifically?
Just because several commissioners asked about it does not mean that the things that they're saying...
Well, one would think a commissioner would know the scope of their authority, so if they are asking and counsel is giving clear legal advice, why is that not an appropriate presumption that they are acting on the legal advice of counsel to the commission?
Well, if that's the case, it's true that if they're listening to their counsel, they are making the decision, but we say there's no reason why that was wrong.
Well, let's assume it was wrong. Let's just, for argument's sake, assume it was wrong. Would the decisions survive?
That's the point that I was making before, Your Honor, that the petitioners never showed how this was integral to the decision. This is a very large project, of which these are two small, one very, very small part of the project.
So the way I understand your argument is basically they balanced this, even if they could do what the petitioners requested, and they decided not to, they were balancing that against the overall project.
The upshot, Your Honor, is they looked at what the statute told them to look at in 25307 for certificate of appropriateness, and that's what they did here.
Thank you, counsel.
Thanks.
Good afternoon. May it please the Court. Michael Hiller, Hiller PC, on behalf of the Petitioner Respondent Coalition.
Counselor, you'd agree here that, that the commission did a rather extensive process, that they followed the procedural requirements of the landmarks law in arriving at its determination whether to grant this certificate or not. Would you not?
I would respectfully, I would not agree with that statement. Essentially,
What didn't they do? They held public hearings, they had discussions, they viewed the site. I think they may have consulted with experts. What didn't they do that the law requires them to do here?
So the beginning of process, whenever you're discussing a certificate of appropriateness, starts with Section 25307 of the Landmarks Law. And 25307 of the Landmarks Law specifically directs the Commission to, first and foremost, look to whether or not the application would result in construction that would effectuate the purposes of the law.
No, I'm not talking about the determination they reached. I'm talking about the process.
I would agree. If you're asking whether or not they had hearings and they had a hearing and a meeting, they did. But that's, again, and I don't mean to quibble with you about this, but in order for them to have followed the law correctly from a procedural perspective, they were required to look to the purposes and goals of the Landmarks Law, and that's where the wheels came off of this determinative process.
Well, we can debate that.
Sure.
But I thought at least part of your argument was that they didn't do that, that at least with respect to these two issues of public access and operation of the clock, all they did, they based their decision on the fact that council told them that they couldn't restrict or make certain requirements. But they wrote a written decision or determination, and they made certain findings, and nowhere in that document do I see any reference to reliance on that legal advice, right or wrong. And so what I'm really getting to is maybe they did, maybe they didn't, maybe it was right, maybe it was wrong, but I am of the understanding that the court may not second guess that, may not question that, may not presume or assume that. They have to go based on what the commission gave as their reasons for approving this proposal. And what they gave was that they looked at all these different factors and that they decided that this met the purposes of the act. So how do we get to question what the basis was?
Okay.
If they
So the First Department made a finding of fact in a very detailed decision by Justice Gesmer, during which she went through each of the statements and comments made by each of the commissioners, and the First Department determined...
So you just said that they made a finding of fact.
Yes.
And I guess that's part of my problem with what the First Department is doing here, because in an Article 78 proceeding, should they in fact be making findings of fact?
With respect to what happened during the during the process, absolutely. That's the reason we have a transcript, and that's the reason, by the way, we know that the commissioners did in fact base their determinations on the misadvice. And this court, in a case called Kilgus, which remarkably is cited by the appellants, specifically said, while it is not for the court to probe the mental processes of the commissioners if it's not clear, if it's in the transcript and the statements are recorded, you can look at those and render determination based upon what transpired. And the First Department did exactly that. The First Department looked at the statements, went through each of them, and made a determination that 7 out of 8 commissioners wanted the clock to remain mechanical. And
I don't know I was a councilman in Buffalo for 13 years, and I sat in an enormous number of legislative hearings. And quite often in those hearings, things were said that were musings on people's positions on a policy matter, perfectly appropriately. I don't mean it. And this, when I read this transcript and when I looked at this record, that's what this looked like to me. Like people were saying out loud, well, could it be this and couldn't be that? And they were musing on it. And usually when you get advice from counsel, you get the advice from counsel, but you also ask for a written opinion if you're going to make that advice from counsel part of your findings that go into the record. And I didn't see those kind of actions taking place here. In other words, it looked much more to me like a balancing of competing interests and how to come to some conclusion about the overall project and how this piece affected the overall project.
What troubles me about the direction of this dialogue now is that at the outset of this litigation, the appellants did not take the position that the commissioners disregarded the advice or didn't follow it. The position of the appellants at the very outset of this litigation was that the advice that was given was correct. And in that regard, if I would just direct your attention to Record 490, 489 to 490, at 489, the appellants recite what our argument is, that the commissioner, that the lawyer for the commission advised the commissioners that they had no right to consider the absence of public access and had no right to require that the clock not be demechanized and that it not be electrified. In response to that, they wrote, contrary to petitioners' claims, the interior designation and landmarks law do not give the commission the authority to require that the clock tower suite be publicly available, publicly accessible, or operated mechanically.
Right.
It doesn't preclude the alternative argument that even if you disagree with me on that legal point, you still, that's not what they
True,
relied
but
on.
because the issue was not raised at the outset and was only first raised at the time after they lost, by the time we're at the first department, it deprived us of the opportunity to say, hey, well, if that's the case, we may have to take the depositions of the commissioners, because the point of the matter is, this is not a preserved point for this appeal. They raised this issue before the first department for the first time, and they deprived us of the opportunity to explore the issue that is concerning each of you, or some of you. And that is a real problem. It's not a situation in which this is an issue that was never before the courts before. I heard quite a bit about teachers earlier, and I do want to emphasize this point. As we all know, the teacher's case involved the designation of a restaurant over the objections of the owner. And opposing counsel said that this court in teachers said that public access is something that could disappear tomorrow. So under the appellant's argument, if public access, if the designation happened on a Tuesday, then on Wednesday, the owner could file an application with the Landmarks Preservation Commission, ask for it to be residentially privatized, the premises, and then, after that point, access is cut off. And when you look at teachers, you know that's not possible, because at page 44 of the decision, and I'm quoting now, the restaurant interior, having been provided for the enjoyment of New York City's residents and visitors since it opened more than 3 decades ago, the Commission now may seek to preserve it for others. And for others is followed by a citation to 25301B. So if I could just talk to you briefly about 301B of the Landmarks Law. The Landmarks Law at 301B has a series of bullet points talking about what the purposes of the Landmarks Law are. And as I said earlier, any discussion of discussion of certificates of appropriateness begins with 25307, which directs you to the purposes at 25301B. And what they are, among others, are fostering civic pride in the beauty and noble accomplishments of the past, promoting tourism, and, most importantly, promoting the use of interior landmarks for the education, pleasure, and welfare of the people of the city.
So those are all purposes, and we've read them. But my question is a more basic one on the advice. As I read the advice, and as the appellate division says, the advice was you don't have the authority to require interior access. You don't have the authority to require that this be, that you don't mechanize it, electrify it. And if that advice is wrong, as you say, what does that empower the commission to do? What does that empower? The advice is wrong. What do they have the authority to do?
In terms of what?
In terms of this COA proposal, what do they have the authority to do if the advice is wrong?
Oh, they had the power to require that the tower clock space remain open. And by the way...
Wait.
Okay, sure.
They have the authority to require that. How do they do that? Do they say, we're accepting your proposal, but there's a few changes we're making in here. We're going to require public access to the clock tower, and we're going to require that you not electrify the clock. Do they have the authority to do that?
Of course they do. In fact, the remarkable thing about this
Where do you
case...
find that, since the authority section for the COA process says you have the authority to approve or deny?
The reason I know that is because the Landmarks Preservation Commission did it in this case. You heard a few moments ago that there was a voluntary undertaking.
Was the banking hall in the proposal, that it would be public? Was that part of their proposal?
Not initially. What happened, if I may just direct your attention to 444 of the record, because this will resolve the issue.
Are you relying at all on 304B for the authority of the commission?
This certainly is the case that the authority of the commission rests in 304B for purposes of use, absolutely, and of course 307E, which speaks specifically to interior designations. But if I may just respond quickly to Judge Garcia's point, you asked how would they do it. If you look at record 444, you will see that the commission said, and I quote, "In voting to approve this proposal, the commission required the applicant to record a restrictive declaration against the property that provided for Point 5, public access to the banking hall, and that the main banking hall would not be used for residential purposes." They could do it, but they didn't do it in this case. And what I have not heard from the petitioners...
Your view is, if they had come in and said, we're privatizing the banking hall, or making that into a condominium, they could have put that thing in there.
And they did.
They came in and said, we're turning the main banking hall into a condominium.
They came in, their initial proposal was not to make the banking hall...
But the proposal that was approved, what was the thing, what was the designation for the banking hall? Was it private, or was it going to be public access?
Public, because the Landmarks Preservation Commission did exactly what they said they had no power to do.
But it wasn't,
the
their
bank-
power to do it wasn't really tested, because the owners said, yeah, no problem. I mean, I don't know exactly at what point in the process they decided that was okay, but
With all due
it
respect...
was an agreement, so that doesn't really test the legality of whether the commission had the power to require it. They were talking about a whole bunch of different things, and they said, okay, we'll do this, but we don't want to do that, and so they came together and they agreed on a proposal that satisfied both the commission and the owners. That, to me, is different than the owner saying, I don't want to do that, you can't make me do that, and the commission saying, yes, we can.
Your Honor, with all due respect, what you've just described as that process is inconsistent with the record. The record, in the certificate of appropriateness, which the panel has suggested to me should be the repository of information as the basis for the decision, does not say there's an agreement. In fact, not a single commissioner on the commission makes even a single reference to any supposed agreement. It was a directive. It was required. It was imposed upon them. And I think that is the critical distinction here.
But I'm a little confused. At the time that the developer purchases this property, it is a designated landmark, is it not?
Absolutely.
It has public access, does it not?
It does.
So where's the opportunity until the commission says otherwise to close the doors and close it off? I'm a little confused by sort of whether it's a negotiation or whether or not the only choice is thumbs up or thumbs down on the request.
That issue comes up when they make an application to alter the space. When they make an application
Yes,
to
but
alter the space.
that's my point.
Yes.
If that's rejected, it stays a landmark. It has the public access. And
Absolutely.
they can't prevent, the developer can't prevent that public access, can they?
In the context of a certificate of appropriateness or some other, I'm sure, I just want to make sure I
Upon the
understand your question.
purchase.
Upon the purchase, that does not allow the developer to close the doors. No, that's
Well, the
correct.
developer can walk away and say, I'm not going to develop it, and the landmark may go into disrepair.
The developer bought the property for $145 million. I don't suspect that there was any real risk that they were going to walk away from the
Let me
building.
just,
And knowing at the time it's a designated landmark.
Yes, and more than that, by the way, in addition to that, the developer here met with the Clockmaster General of the City of New York, Marvin Schneider, and actually went through with him and talked about the clock and how he needs access and how it's wound and how he takes tours there every week. And with that information, he still purchased the building.
Section 311 also requires the owner of a landmark to maintain it, no?
It does, and that's significant because Marvin Schneider, who's the Clockmaster General, and his deputy, Forrest Markowitz, as well as one of the foremost experts on tower clocks in the United States, Chris DeSantis, all said that disconnecting the clock from its mechanism would actually force it into permanent disrepair. It would destroy the clock. And in addition, the curator and the executive director of America's Watch and Clock Museum in Washington, D.C., which has no connection with this lawsuit at all, submitted a statement saying exactly the same
Let's say
thing.
they bought this building and then they run out of money. Happens. The building's empty, it's boarded up. Can they bring an enforcement action to make the owner open the boards and bring people through to tour it? Or can they say, look, the clock's not being wound, you have to wind the clock? Do they have the authority to do that?
If the owner is suffering from a hardship, there's a wonderful provision under Section 25309 that allows for an application. And by the way, that's an exception to 25307. 25307 is the process by which applications are made to renovate space. And it states in 25307 that if it does not satisfy the purposes of the landmarks law, you shall deny the application. The only exception to that is similar to what you've just raised. 25309 specifically gives the owner an out. And to me, that really is where we are here. Because if you think about what the purpose of the landmarks law ultimately is, because ultimately what the decision that this court makes will decide really for whom the landmarks law was enacted. If the landmarks law was enacted for the purpose of making properties, interior designated landmarks, and other properties available to the public for their education, welfare, and pleasure, as set forth in 301BG, then the answer is there must be some minimal level of access.
Here's my concern. If too many restrictions are put on people, they won't buy these properties. And I think the landmarks law is very, very clear that it was intended to promote private ownership and maintenance of these landmarks, so that it didn't rest on the government. So, I mean, I think in the long run, it could disserve this purpose.
Well, Judge Stein, the alternative to that is that developers will acquire interior landmarks and then immediately privatize them. And I can tell you that at Record 119, you will see there's
only if the Landmark Commission is willing to let them do certain things. They can't just walk in and do it, as you said.
No, but what they could do is make the same application this developer made here, and the outcome of this appeal will determine whether or not the commission will grant or deny that application.
But aren't they balancing also different things? And I think a number of people have raised this. And an exterior landmark, a building landmark, will walk by the clock tower outside. You can see the clock. Not a takings argument, but there certainly are takings issues here, where you designate an interior space and you're going to say, no way, no how, from now until eternity, you need public access to this. That's a very different calculation than designating the clock tower that you see from the outside. So isn't that what they're really getting at with the purposes of it, and giving the commission, which they appear to have used here, the discretion to look at all those purposes and all this space and approve or disapprove a plan?
The answer to that question actually lies in what the statute initially said in 1965 versus what it said in 1973. When I was preparing for argument last night, I had a lot of trouble, but I did find it. What's interesting about it is that in 1973, the statute was amended to include protection for interior landmarks. And when they did that, they had to obviously sprinkle interior landmarks throughout the statute to make sure that it fit in with all those places. One place where they were very clear was in 301BG. And 301BG states, and I just want to, it's so important, it says that among the purposes of the landmarks law is to promote the use of interior landmarks for the education, pleasure, and welfare of the people of the city. Now, it's interesting that they did not include interior landmarks in a couple of others, but they did in this one. And if you cannot use if you cannot see an interior landmark, then it certainly cannot even begin to satisfy that purpose. And then going to the others as well, you can't promote tourism if people come to New York to look at it but can't see it.
But you have to satisfy every purpose.
I think
it doesn't say that. It says consistent with purposes. So each purpose, tourism, well, this really doesn't promote tourism, so you can't do it. And, it's arguable this doesn't. But I see that as, look at the purposes, make a determination, given their expertise, given the people that are on the LPC, make a determination whether this is consistent with that.
But the problem here is that commissioners on the Landmarks Preservation Commission wanted to consider public access because it is among the purposes set forth in 301B, and they were
Let me ask you about
sidetracked
that.
on
Let me
that.
ask you about that directly.
Sure.
Had they gotten what you deem to be the correct legal advice,
Yes.
could they have reached the same decision after balancing everything?
No.
Why?
Because there has to be some minimal level of access. Has to be some level. It doesn't have to be 24/7, and there's no risk that people are going to be...
So in your view, they couldn't conclude, they might be, let's say we're faced with a little bit different set of circumstances where the building was going to fall apart and crumble, or they found one party who was interested, but the only condition they would take it on was dismantling removal of the clock, and that was their option. You're saying they couldn't balance that and conclude, we're going to have to lose the clock to preserve the whole building?
Judge Wilson, I'm sorry, I misunderstood your question. I thought you were asking about this particular property as opposed to in general. If we're talking about this particular property, which is what I thought you were asking about, the answer is they had to consider public access. They had to.
To consider it.
But, right, they had to consider it, and in this instance, in the absence of a rational basis for privatizing this clock tower, the answer is they had to make it available. And I would say to you, I've read all of their papers, I still haven't seen the place where they say...
What if the rational basis was the public can still see it? We're preserving it, we're preserving all the mechanics, and we have this building that has a whole bunch of other interior landmarks, and they're getting preserved, and they're going to be open to the public. Why isn't that a rational basis?
Okay, there is a lot in there. I just want to unpack that. With respect to the exterior seeing on the outside, this building is both an exterior landmark and an interior landmark. And there's no precedent whatsoever for the proposition that you can sacrifice an interior landmark because you can see it from the outside.
The clock faces.
The clock faces from the outside.
Yeah,
But that's exterior. We're talking about the mechanism itself.
No,
We're talking
that's
about the
sort of
clock tower
accommodation.
suite, which has been open and available to the public from 1972 to 2013 when the art gallery was unceremoniously closed. This was a regular place that was visited by people to see the space. Now, the balancing that you're talking about, that balancing process never had its opportunity to truly mature because while the commissioners were asking the question, can we consider, we want to be able to make it
All right,
available.
counsel, we know your argument on that, and your light has been off for quite some time. Judge Garcia has a question.
It
Please
wasn't, my problem with that is it wasn't, you can't consider, going to Judge Wilson's point, it was you can't require. So isn't that a difference? I mean, here's this appellate division majority. The LPC's counsel responded that LPC does not have the power under the landmarks law to require interior designated spaces to remain open. That's a quote, and quote, to require that the clock mechanism remain operable. So is there a difference between telling the commissioners you can't require that, you can't line item veto a plan, versus you can't consider that at all and looking at the purposes of the landmarks law?
Well, if you say you cannot consider, if you tell the commissioners you cannot consider whether or not the absence of public access is inconsistent with the purposes, we cannot require ever that an interior landmark be available to the public. If that's what he's saying, then you're effectively discounting that as a consideration altogether. If you look at one point at 785, at 785, Mr. Silberman of the Commission, the lawyer, said there is no power on the landmarks law to require interior designated landmark spaces to remain public. And 786, there's no power to require them to remain
That's
public.
the language I just quoted,
Right.
but it goes to requirement rather than you cannot consider that in rejecting or accepting the plan. Isn't that Judge Wilson's point? I mean, they could consider it. They could just consider that it doesn't overcome the other things in the plan that they believe are appropriate and they want to approve.
I think if you review the transcript in its entirety, you can see very clearly the trajectory of the deliberative process stopped when this issue came up. There was no opportunity to engage in the more I don't want to use the word Talmudic, but a much more detailed analysis that you're discussing. And I just want to answer Judge
it's your
Stein's
last
question.
point, yes.
Yeah, just to answer Judge Stein's question, because I didn't get to finish it. You said, what about, difficult to get to? Because I think you said, maybe they decided this one's more difficult to get to. It's at the top of the tower. I would just point out that at 784 and 785 of the record, you'll see that the architect for the developer was specifically asked whether or not it was possible to make the tower accessible to the public. And he said, it is possible. We have no intention of doing that. I would just leave you with this last point. I still have not heard from the appellants why it advances the purposes of the landmarks law to residentially privatize this space that has been open and available since
Thank you, Counsel.
1898. Thank you.
Few points, Your Honor. I hear my adversary to speak about the Landmarks Commission allowing for residential privatization. The Landmarks Commission did no such thing here. It was not the Landmarks Commission job to tell.
Let me just ask, what recourse does an owner, developer have if, taking Judge Wilson's hypothetical, the property is falling apart?
There,
Recourse to avoid any kind of demand by the commission? Can the commission make a demand that they maintain the property? What recourse do they have?
there are hardship provisions that I really will not speak to because they are in the statute and I don't have a very extreme familiarity of them, a very detailed familiarity of them. Here, I will say the only requirements on the property owner are two things. Under 311, keep the property in good, keep the features in good repair. Two, come to the Landmarks Commission for work, to get work approved. The commission only deals with work. I know Your Honor was talking about, well, what if it's no longer a landmark? Designation is a starting point, and we know that because in 25307...
Is there not a process to eliminate the designation, to rescind the designation?
Yes, Your Honor, but it's an extreme...
And isn't that what the developer should have done?
The developer could have done that, but it's an extreme situation.
No, should have done that.
No, because...
Why not?
Because the developer was asking this was a large-scale restoration project, and they were looking...
But I'm just talking about the tower. I'm just talking about the tower right now.
I don't know.
The clock mechanism. That's what I'm asking you about. If they no longer, look, they want to make millions of dollars off it, fine, it's a capitalist country. They think that having public access and maintaining the mechanism in its original condition or the way it was intended to be used somehow means that it won't be as marketable as they want it to be, or won't be marketable at all as whatever penthouse or condo they were going to make it. Why isn't that what the law provides as their recourse? Because they bought it knowing it's a landmark. So if they no longer want it to be treated as a landmark, doesn't the law provide them that mechanism? Shouldn't they have used that? That's what I'm having difficulty with here.
I can't speak for the developer, but from the commission's perspective,
Yeah.
we would like things to be landmarks. We would like to maintain jurisdiction. If there was a
And
rescission...
isn't it difficult to get something landmarked?
I can't speak to how difficult. I will speak to the difficulty of interiors.
My understanding is it's not an easy task.
And the interiors, there's only 117.
Counsel, if you go and you do this process and get it delisted, let's call it, all bets are off, right? Then you can
You could do anything
disassemble the clock, you can take the mechanism out, you can knock the tower down, you can do whatever you wanted.
And it's not a guarantee that the commission would approve that.
No,
Here,
but let's say they do. Let's say you go in and you make that hardship case and they approve it. Then you can do whatever you want to that clock. Whereas here, you have to go to Landmarks Commission, they can approve, they can disapprove, you're preserving the mechanism. So is it really a policy you would want to encourage, to have people who are in this situation go and get this de-designated, so all bets are off, or go to the Landmarks Commission where you can present a proposal that balances those issues? It seems to me to say, hey, if you want recourse here, go get this delisted, which the commission can certainly do under the right circumstances. Why would that be the appropriate course to take?
well, I think as a whole, it'd be less preservationist to do that. The commission retains jurisdiction. The commission retains jurisdiction over the features. Here, in this situation, the commission will always be there to look at the features and see how they're preserved and approve all plans for preservation so that this can be preserved.
And in fact, there's a permanent restrictive covenant saying that they have access and they get to inspect.
They
right?
did enter into that. I know my adversary made some agreement. Is there some shadiness that went on about this? I don't think so. I think that there was they could not mandate it.
No, I don't mean public access. I mean, the commission has access.
Yes, we have access. Yes, we have access to inspect at all times. And I will just emphasize that a categorical public
Can I
access.
just clarify? Is the commission the body that can indeed rescind a landmark designation?
I would point you to the provision, which I think is 303, and it also requires city council and mayoral approval. So it's a very exhaustive process to get rescission of a designation.
Doesn't that, at a minimum, suggest that the treatment of a landmark, once you go through that process, and it's not an easy process, it's a costly process, that to rescind that designation, the city takes it seriously, that it's actually going to the council, it's beyond the authority of the commission?
Sure, we take it seriously, but the commission
I'm
itself.
not asking if you take it seriously, I'm asking about the council taking it seriously.
Well, I can't speak now for the city council. I mean, the city council spoke when the city council drafted the legislation. It allowed for this to happen. I will point out, I will emphasize what the city council did not do was impose a public access mandate. It could have done that. It should have done that because
If we disagree with you, did they win?
I think, Your Honors, I think Judge Stein in particular, Your Honors have pointed out that there are ways that this project was rational, this project was reasonable. At the end of the day, what matters is 25307.
Thank you, counsel. Thank you. Counsel?
Just two quick cites and then two other points. One is a cite to the Weinberg v. Berry case, 634 F. Sup. at 93. It also makes the point that public access is not necessary to achieve the purposes under the statute. It dealt with the D.C. statute, which is very similar. And the reason it doesn't is because one of the goals of the primary purpose is preservation. And we want preservation even without public access because it preserves the property for future generations. That's what the case says. That's what the law.
Okay, so then how is this particular clock preserved if you're unplugging part of this mechanism and you're changing the way it functions, which was part of the reason it was designated?
It all stays in place and could be, that evidence was presented that it could be put back together
gas
and
lamps.
mechanically operated. And we do not want owners, like this owner, to buy these properties and rescind. There are many owners that
Rescind-
like
I'm
this
sorry,
one,
rescind what? I
rescind
lost-
the landmark designation. What we want to do is there are many landmark owners, they want to preserve it. It's part of the whole project is to have these beautiful landmarked features preserved. And the policy is to encourage them to do that. And also, if you look back, it goes all the way back to Penn Central. It's not going to happen under public ownership. It didn't happen under public ownership. When the city owned it, they had scaffolding for 10
But
years.
you
so
don't
people
have
didn't
anything
get-
in the record that suggests that developer would not make a fair market value return if indeed they could not do what they wanted to do with the clock tower.
No, that's not the takings argument. The takings argument is one, the effect on other buildings and properties, a restaurant that can no longer
No,
function.
but we're talking about this property.
Yeah,
My question was about this
I
property.
think the takings argument is an interesting one, which is what makes a property private? Being able to decide who comes into it and who doesn't.
Sure.
This is worse than eminent domain. To take somebody's property that they bought and say, you keep it up, you repair it, you use it, except for we can control who comes in, when,
Yeah, but
why,
that's
and how.
that's actually not the understanding of that whole takings line of jurisprudence, because of course, the developer here bought what was designated a landmark. This is not where you have property and your rights, that bundle, right? That bundle of rights is, sticks are being pulled out and somehow you're being
I don't think the-
compromised in that ownership. you know?
No, I don't think that question was answered, that I'm raising was answered in Penn Central. But in any event, when they bought it pursuant to a landmark, it was never intended at the time of the designation to have public access. If you look at Record 495, it's that volume that is the printed out copies of the CDs. There's a picture in it at LPC 81, and you can't get to the clock tower through the designated portions. If they had intended that it be publicly accessible, they would have allowed access to it. And in fact, it wasn't, many of the landmark spaces were not accessible at the time. If you look at 1029 of the record and 786 of the record, the city had closed off access to certain landmark offices. So, but I think this comes back to this fundamental goal of, two goals. One is preservation without public access is a very important goal that should be pursued. And the answer to, and we want to encourage people to preserve, because otherwise building owners will not buy these buildings if there's too many restrictions on them. They won't find return.
What about denying public access, ending public access, but maintaining the functioning of the mechanism as it was when it was designated?
There's just there's just no basis in the statute to say that that has to be done that way, and the problem
But if that's the point, just take my
Yeah.
hypothetical. Let's say that's the point of the designation. There's something so unique and of historical value and consequence of the functioning, right? Even if you say no more public access, either because it might degrade the functioning, or you want to profit in some other way, right? Why doesn't that fit within the purposes of the statute?
Well, you could read the statutory purposes quite broadly, but there's no statutory language and no ability to effectuate that and require that and police that. And if there were, then one could think of the problems that would create about fireplaces and gas lamps and all of the other things would have to be kept functioning. And would this really be kept functioning? There's a time. Nobody's preparing or making parts for this clock anymore. And to what expense and how far would an owner have to go?
But wouldn't that be sort of then that's when the owner comes back and says, look, I can't, I would love to do it, but I can't do it. That's a different scenario, is it not, than when you're still able to do it, but you choose not to?
Yeah, you choose not
request
to
not
because
to.
it's your right not to, and the Landmarks Commission...
because you request not
right.
to, yeah.
If the Landmarks Commission, if the City of New York wants to require owners to operate interior landmarks in a specific way, they should amend the statute to require that. It will set back development. It will set back the purposes of Penn Central, but they should do that. That should not be placed on this one owner, only because clocks have a great appeal to all of us, including this owner. Whereas maybe people don't care quite as much if the gas lamp keeps burning or the other interior architectural features keep
Well,
functioning.
gas lamps aren't as unique in the way I think you're suggesting. Maybe there's a Tiffany
They
lamp,
certainly are
but we
unique
know what
these
gas
days.
lamps are, but this clock is unique. But
Yeah, I mean, and there
appreciate
are
your
other
point.
landmark interior features that are quite unique that would have to be kept. But again, that uniqueness is not something that's built into the statute that would say, under these circumstances, and here would be the factors under which you would have to determine whether or not to keep something running continuously in the particular mode. That should be written into the statute.
Thank you, counsel.
Thank you.
Thank you, everyone.